Alice and I are always looking to be more healthy, and we were just talking about how fasting is one of the best ways to do that, but it's so hard. But the great thing about Prolon is that's not what you're doing. It's not that you're not eating for 5 days. Instead, you're using their science-backed program to convince your body you're fasting.
You guys, this 5-day program really is amazing. It comes beautifully packaged and it does all the thinking for you. Each day is its own box. And by following their program, I know I just feel so much better. And I can't wait to experience Prolong Next Gen and continue to see results. For a limited time, you can be first in line to experience the new Next Gen at special savings. Prolong is offering the Prosecutors listeners 15% off site-wide plus a $40 bonus gift when you subscribe to their 5-day program. Just visit prolonlife.com/prosecutors. That's PROLONLIFE.com/prosecutors to claim your 15% discount and your bonus gift. prolonlife.com/prosecutors.
Hey guys, this is Brett from the Prosecutors, and I want to talk to you about one of our favorite podcasts, Compulsion. Compulsion is a fully scripted, one-narrator podcast that strives to bring new information to even the most seasoned podcast listener. Their team works to bring you cases that you've never heard of before. They dig through historic archives and local news sources to find the stories that need more attention. Occasionally, they even interview witnesses and family members involved in cases who want to share their stories. They do delve into some of the more famous cases as well, and if they find new information to bring to light, they share it with you. Or if they can correct facts about a case that has a lot of rumors or speculation, that's something they strive to do and is so important in the true crime community. They also look at how social media in the modern age is changing investigations and cold cases. As we've always said, the way you solve cases is you get attention on them, and podcast and social media is one way to do that, and Compulsion is diving into that truth. So, if you're looking for a show that brings you something new, check out Compulsion on your favorite podcast app today. I'm Brett.
And I'm Alice.
And we are the Prosecutors. Today on the Prosecutors, we explore the ongoing trial of Derek Chauvin and the death of George Floyd. Hello, everybody, and welcome to this episode of The Prosecutors. I'm Brett, and I'm joined, as always, with my daring co-host, Alice.
Hi, Brett. Am I daring
Hi,
because am I daring because we have decided to embark on covering this trial that I think everyone in their sound mind would advise us against doing?
Probably, Alice. Probably.
And, the reason everyone would advise against it is I think it would be difficult to not anger some people. But I actually feel very strongly about this, that when there are heated topics, especially in popular culture, and these issues are very important, but we have to be able to talk about them about the facts, and we heard a lot of people saying, I just don't exactly understand what's going on. I wish someone were able to explain it to me without kind of the drama surrounding it. So that's what we're going to try to do. And we haven't even stated what we're going to do, Brett.
Yeah, well, we're going to talk about the Derek Chauvin case that's ongoing. Everybody, I think, in America knows what I'm talking about. This is the trial of the police officers and the police officer who was most involved in the death of George Floyd in Minneapolis, Minnesota in 2020, a death that caused a lot of protest, a lot of introspection, a lot of people to question our justice system and race in America, all sorts of hot button issues. I think that's what Alice is referring to. People feel very passionately about this case. And I know some people would probably shy away from this, but we're not going to do that because we do think we have some expertise we can offer. A lot of people have asked us to cover this case, and I think a lot of people have a lot of questions. Now, look, we've said this before. We are active prosecutors. We are out there prosecuting cases. We normally shy away from cases like this that are ongoing for that very reason. We have ethical obligations not to get too opinionated or involved in political issues and that kind of thing. And so don't expect a lot of opinions from us. That's not really what we're doing here. We're not going to be preaching to you in this podcast. We really want to walk you through the procedure and the facts. We want to walk you through the witnesses. We want to walk you through the law. We want you to have an understanding of all that background. And when you're listening to this trial and when you're looking at the evidence, we hope that will help you reach your own conclusion, free of what people want to tell you to believe or, different sides pushing you in different directions, where you can reach your own conclusion about the way this trial should go and whether justice is done in the end.
Well, with that, Brett, why don't you give us a little bit of background? We're already in the middle of trial, obviously, but take us back to May of 2020 when this all occurred.
Absolutely. And we are in the middle of trial. When you're listening to this, I think you'll be in the third week of trial. The way we're going to do this, we're going to cover the first week of trial this week. Next week, we'll cover the second week, et cetera, until it's finished. And, one thing you'll probably get out of this is you'll definitely get some multiple episodes. Normally we do one episode a week. Probably going to be doing at least two because there's so much going on here. Like Alice said, to understand this, you have to go back to May 25th, 2020. And on that day, Derek Chauvin, along with 3 other officers, responded to a report that a man had used a counterfeit $20 bill at a local convenience store in Minneapolis, Minnesota. The officers took this man, who turned out to be George Floyd, into custody. But as they approached the police car, Floyd stated that he had trouble breathing and that he was claustrophobic and he didn't want to get into the back of this police car. At some point, he falls to the ground, and what happened next becomes famous around the world. A bystander recorded Chauvin perform a variation of what is called a knee-to-neck restraint, in which he knelt on Floyd's neck for over 9 minutes. During this time, Floyd repeatedly said he couldn't breathe and called out for his mother. Floyd then went limp, and by the time Chauvin stood up, Floyd had no pulse. He was pronounced dead shortly thereafter.
And part of the reason this may sound very familiar to all of you is a bystander recorded this incident on their phone, and this video really ricocheted around the country and has been viewed by just about everyone. We'll come back to this because it is obviously a very strong piece of evidence, an emotional tug for the prosecution, and also it makes this case so well known because while Brett has just told you the story in storytelling form, to see it is very different. Not all crimes are captured on video, and this particular incident was captured on video. Now, let's talk about the charges. But first, let's talk about what Chauvin is not charged with. He is not charged with first-degree murder. Now, this was controversial at the time, as both the family and some commentators demanded that a first-degree murder charge should be on the table. So, why wasn't it? Here's the definition of first-degree murder, which carries a mandatory sentence of life. It is whoever causes the death of a human being with premeditation and with intent to effect the death of the person or of another. Just in me reading the definition, you can see why the prosecution would have had a very difficult time proving first-degree murder. Premeditation is difficult to prove in the best of cases, but with kind of a chance encounter here, showing that Chauvin decided to kill Floyd would be an extremely difficult showing for the prosecution.
And I think sometimes people who are not in the legal profession, they just think of first-degree murder as the worst murder, right? Like, it was a really bad murder, so it should be first-degree murder. And anything less than that isn't respecting the victim. But the prosecutors, they have a very heavy burden if they're going to try and make a first-degree murder charge. And one of the commentators I read said something like, well, yeah, it's a really heavy burden, but Mr. Floyd deserves to have this, and if the jury doesn't want to convict, then so be it. They can convict on a lesser charge. And we've talked about this before, this notion of, as a prosecutor, you should just say, well, probably not good enough, but we'll roll the dice and let the jury decide. That is not what you should be doing as a prosecutor. You have to make the really tough calls. And if these prosecutors didn't believe that they had the evidence to prove first-degree murder, it would have been unethical for them to bring that charge and just roll the dice with the jury. And I don't think that's any different here than it would be in some of these actual innocence cases we've looked at, where it seems like the prosecutors are pretty sure that they don't have the evidence to convict, but they go ahead and try anyway.
And that's right, Brett. When you say the word ethical, that's not just, pie in the sky. Is it ethical or not? What is the gold standard for prosecutors? That's actually in the model rules of conduct for like the American Bar Association that most states have actually adopted as their own model rules of conduct for all practicing attorneys. So it's not just an ideal that attorneys are supposed to reach for. It's actually something that you could get ultimately disbarred for if you act in a manner that is contrary to the rules that we are all bound by. So what he is charged with is second-degree unintentional murder. Now, this charge carries with it a maximum of 40 years in prison. And the elements of second-degree unintentional murder is this: whoever causes the death of a human being without intent to affect the death of any person while committing or attempting to commit a felony offense.
And you see here the difference. So we talked about first-degree murder and how they couldn't charge that. At the end of the day, they didn't even charge intentional second-degree murder. The highest charge in this case is unintentional second-degree murder. So they're not going to try and prove that Chauvin intended to kill George Floyd or went into this deciding he was going to kill him. They recognize that's just that's something they can't reach. So what they're really going to focus on were his actions, what he did that lead to George Floyd's death in a way that allows him to be convicted of one of these charges, and this is the first one.
There are two additional charges that are brought in this case. The second one is third-degree murder. Now, this carries a maximum of 25 years in prison. The elements of third-degree murder are whoever, without intent to affect the death of any person, causes the death of another by perpetrating an act imminently dangerous to others and evincing a depraved mind without regard for human life. Now, this charge was initially dismissed by the court as Minnesota law had previously required the actions of the defendant to have endangered more than one person. But following an appeals court decision clarifying the law, the charge was then reinstated. But the defense opposed the reinstatement of this charge because they wanted to force the prosecution to meet the higher burden necessary to prove second-degree murder or go for manslaughter. So as you can see, there's charging decisions, but then before you even get to trial, there are motions practices. And in this case, the defense actually sought to dismiss one of these counts, and they were successful before an appellate court then reinstated the charge. So when you ultimately see a trial, a lot of litigation has already happened, and this is just the end of the case, if that makes sense. Now, the last charge that was brought against Chauvin is second-degree manslaughter. Now, this charge carries a maximum of 10 years in prison. The elements of second-degree manslaughter are whoever, by their culpable negligence, creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another. So you can see just by the definitions of each of these charges how the level of proof needed is very different, and it really goes to the mind of the actor.
Yeah, and it's really interesting to look at these charges because in other cases, you'll often hear people criticized or prosecutors criticized for their charging decisions. A famous example of that was in the Casey Anthony case, where people have said that the prosecution, by pursuing the first-degree murder charge, really set themselves up for failure. If they had pursued some lesser included offenses, some lower levels of murder, and given the jury the option to convict on those, then she may not have been acquitted. The opposite side of that, of course, is that if you truly believe that someone, take this case, is guilty of second-degree unintentional murder, then maybe you don't want to give the jury the option. You don't want a compromise verdict. You don't want people to say, well, he may be guilty of this very serious crime, but it would be a lot easier and I'd feel better if we just said he's guilty of manslaughter and move on, right? You don't necessarily want that. In this case, it's very interesting to see this because they've given the jury this spectrum that they can make a decision on, all the way from what Chauvin was doing was a felony. And even if George Floyd had not died, if nothing happened, they put the knee on the neck, they do that for 9 minutes, somebody else shows up, they get him up, they put him in the back of the car, drive off, and he's charged with counterfeiting, and there's no, he doesn't go to the hospital, he doesn't die, nothing like that. Even if that were true, that action itself is a felony, and so you would be, the officer could be charged with that. It's all the way from that all the way down to this culpable negligence thing where he just creates an unreasonable risk that results in death, which is obviously a much lower burden for the prosecution, but also carries a much lower sentence from 40 years in prison to 10 years in prison.
And I just have to note real quick, on the second-degree murder, one of the reasons that people were upset that first-degree murder wasn't brought is because the maximum sentence is life. But you'll see that second-degree unintentional murder also does carry a maximum of 40 years, which for many people, a 40-year sentence is essentially a life sentence. So keep that in mind, though you say life versus 40, in essence, they can really be the same type of sentence.
So let's take a look at the players in this case, and we'll start with the prosecution. Now, obviously, there are a lot of lawyers involved in this. This is a big case. These folks are going to be having help, but these are sort of the main people. The lead prosecutor in this case is Matthew Frank. He is an experienced prosecutor who probably is most famous for securing a guilty plea in a case that we have covered previously, the case of Lois Race of Worm murder fame, and Jerry Blackwell, who is another experienced prosecutor. And if you watch the opening statement from the prosecution, he is the one who actually gave that statement. They are going to be handling the case for the state. The defense is headed by Eric Nelson, who is also an experienced attorney who has handled multiple other murder cases in his career. In some states, and I don't know if this is true in Minnesota or not, you can't actually handle a murder case unless you've been at least second chair on a prior murder case. They don't want, they don't want like brand new lawyers coming out to handle a murder case. But Eric Nelson has a lot of experience in this area. We also have the jury, and jury selection took a while. We'll talk about jury selection, but eventually the jury is made up of 12 jurors and 3 alternates. You won't know until the end who the alternates are.
And let me note that the reason you have alternates is they expect this trial to take some time. And even if it's a short trial, you have alternates just in case something happens. Someone falls ill, someone has to be rushed away on some family emergency, there might be jury misconduct. Let's say a juror goes home and tweets about things and they have to be dismissed. You don't want to have to then start the whole jury selection process and a whole new trial just because you have fallen under the number 12 for the jurors. So 3 alternates is on the higher side, but I think it's appropriate in this case because they do expect the trial to go on for a matter of weeks, if not longer. And when we say that you don't know who the alternates are until the end, that includes the jurors. The jurors don't know who the alternates are. And what's the reason for that is that you want everyone to have full attention. Everyone thinks that they are the juror, and they are. They potentially are the juror until the end. And even when the jury is dismissed to go deliberate, after closing arguments, after both the state and the defense have rested and the jurors are sent to the back room to deliberate and come up with their verdict, the alternates are told they are alternates and they are sent home, but they are told to keep their phones on in case something happens during deliberation where a juror has to leave. You still need 12 to reach a verdict. And so jurors, even the alternate ones, are not off the hook until the verdict is returned.
And you saw that in the Scott Peterson case where you lost some jurors during deliberation. And in fact, one of the jurors who's so controversial in that case was an alternate who came in sort of halfway through deliberations. Now, they have to start over as if they hadn't done anything, but it is a sort of an interesting aspect of this. As far as the racial makeup of the jury, 9 of the 15 jurors are white, 4 are black, and 2 identify as mixed race. Now, people have asked us before about jury selection. It's not something we've ever talked about before, but this seems like as good a time as any. Let's talk about it briefly because I don't want to take away too much from the case, but jury selection is interesting. So every juror who is a prospective juror receives a juror questionnaire. If you've never served on a jury, you probably never had one of these, and they ask some really interesting questions. You know, I've seen them where they ask, what talk radio do you listen to? For prosecution and defense attorneys, you know, if you listen to NPR, that might make them think differently about you if you say you listen to Rush Limbaugh or Sean Hannity or somebody like that. Whether you go to church. All of these sort of factors about your life where the lawyers are trying to figure out the kind of person you are and how you think about things. There are certain things you can't consider. Race is one of them. Gender is another. There are 2 Supreme Court cases that deal with that. And interestingly, the reason behind that is it's not about the fairness for the person who's being tried. So we're not saying that, you know, for instance, if you have a white defendant and you have an all-black jury, that defendant can't get a fair trial. We're not saying that. Or if you have a black defendant and it's an all-white jury, that jury can't give that defendant a fair trial. We're not saying that necessarily. But what we are saying is if someone is denied their right to serve on a jury because of their race, that is a violation that is so fundamental that it invalidates the entire trial. The entire trial has to go away and you have to start again. And that's the way that's been interpreted. But beyond those 2 factors, beyond race and beyond gender, you really can consider just about anything when you're deciding how to use a limited number of strikes that you can use essentially for no reason or any reason at all. When you're picking, you're driving that number down from, say, the 100 people who show up to the 15 people who are going to serve on that jury. And in this case, it took about 2 weeks to get there. And the last thing on this, there was an interesting pretrial agreement that was made in this case that was immediately they stopped following. And that's that the parties agreed that Chauvin would not be referred to as the defendant and Mr. Floyd would not be referred to as the victim. And I guess this was to avoid sort of language subtly poisoning the jury one way or the other. I will say, just reading through the transcripts and listening to some of the testimony in this case, Chauvin very quickly became the defendant. I don't know that George Floyd has been the victim very much, but it certainly has not been the case that they've avoided calling him the defendant. I don't really understand exactly why they wanted to do this. I don't know that it's necessarily prejudicial to Chauvin to be called the defendant. He is the defendant.
I think some of the issue is it can be a tactical thing to call someone by a title that is really faceless. And so by calling Chauvin the defendant, you are not giving him the credence of calling him with a Mr., right? Otherwise, he'd be Mr. Chauvin. And so this way, it kind of dehumanizes or at least makes the person you're supposed to convict more faceless and maybe takes away some of the thought that he, has a family and whatnot. This is a tactic that people use within the courtroom often. You'll also see this with how attorneys refer to each other in court. While I personally like to call my opposing counsel by their names, Mr., Ms., I just think it's respectful. A lot of times you'll find attorneys who only call opposing counsel or counselor or my friend on the other side, something like that, so that you don't even give them the benefit of having a name.
Or the government.
Or the government. We often get, we get the government or the state or the prosecutor. We get that a lot too. Well, the prosecutor said. And these are just all small ways of using words to shape how people view people.
It's kind of like in jury selection. I worked with a guy once who said when he does jury selection, he would always pick the first 12 jurors. And he did it like in a very sort of showy way that whoever the first 12 jurors were, that's who he's picking. He wouldn't use any strikes. And the reason he would do that is he wanted to send a message to the court and to the jurors and to the defense counsel that it doesn't matter who's on this jury. The evidence is with me, and I'm going to win. So it is interesting, sort of the little psychological games people play in trials.
Now let's turn to the opening statements. Once you pick your jury, the next step and the first step is to give opening statements. Now I say the next step rather than the first step really is because at this point, the jurors have seen the defendant. They have seen the attorneys for quite some time. In this case, for 2 weeks. They have gotten to know the mannerisms of the attorneys. And by this time, people in the courtroom, the judges, the attorneys, the defendant, have actually all already made an impression on the jurors. I note that because the judging really starts before the opening statements. And I think all good attorneys know that. That's why you should be conducting yourself with decorum and respect even before trial officially begins, because jurors are watching. But with opening statements, this is the first time you get to directly address the jurors and tell your side of the story. Now, opening statements are supposed to be just that. They're supposed to be laying out the whole story and theory of the case from your point of view. So the prosecution lays out what they think happened, and the defense tries to poke holes in it. This is really important because essentially what you're doing is you are setting the scene for the jurors to think about the case in your way. It's been described to me that opening statements is like you're building a bookshelf, those built-in shelves. You see this blank space in a room and you take out your measuring tape and you start building this shelf. And the evidence you will present throughout trial, you're giving the jurors to put on different shelves that you are building. But because you're building the shelves, you really have to be you are the one who sets the scene. How you build the shelf can really affect what type of evidence fits in it. And so we've said this time and time again. The best story wins. So what is the story that the two sides are trying to tell? Ordinarily, the first few sentences will tell you what the story is going to be. We'll start, as every case starts, with the prosecution. Now, Jerry Blackwell lays out the case for the prosecution. After some pleasantries, he begins, "You're going to learn in this case a lot about what it means to be a public servant and to have the honor of wearing this badge. It's a small badge that carries with it a large responsibility and a large accountability to the public. What does it stand for? It represents the very motto of the Minneapolis Police Department, to protect with courage, to serve with compassion, but it also represents the essence of the Minneapolis Police Department, approach to the use of force against its citizens when appropriate. The sanctity of life and the protection of the public shall be the cornerstones of the Minneapolis Police Department's use of force. Compassion, sanctity of life are cornerstones, and that little badge is worn right over the officer's heart." So you can see from these beginning sentences, the prosecution has established this notion of the badge as representative of everything a police officer is supposed to do. The badge is already a symbol, and they are reinforcing that symbol. He continues, "The symbol of public faith, ethics to police service, sanctity of life. All of this matters tremendously to this case because you will learn that on May 25th of 2020, Mr. Derek Chauvin betrayed this badge when he used excessive and unreasonable force upon the body of Mr. George Floyd. That he put his knees upon his neck and his back, grinding and crushing him until the very breath, no, ladies and gentlemen, until the very life was squeezed out of him. You will learn that he was well aware that Mr. Floyd was unarmed, that Mr. Floyd had not threatened anyone, that Mr. Floyd was in handcuffs. He was completely in the control of the police. He was defenseless."
And I recommend we're going to post some links to some of this stuff on our website. And I recommend listening to this because you can tell just by how Alice is reading it, this is a really good opening statement. And this creation of this symbol and the badge, it's really interesting because so much of this case has become wrapped up in the police overall and the police brutality and are the police a force for good. And in this statement, he's putting all that aside. He's saying the police are a force for good. And this badge represents what they're supposed to be. This badge represents what they're supposed to do. And Mr. Chauvin's not an example of the police. He's an example of someone who's betrayed the police, who's betrayed the badge, who's betrayed his oath. He is not a police officer. He's a criminal. And that's what he's really saying here. And it's very effective the way he does it.
Right. Because essentially he's not having to fight two fronts, right? The two fronts being that the police are bad and that Mr. Chauvin is bad. He really just has to show one thing. And in fact, he's juxtaposing the goodness of the police with kind of this bad seed within what should be a good police force.
And we'll see this again and again as we look at the witnesses. It's not the prosecution against the police. The police are with the prosecution. It's the police and the prosecution together against Chauvin.
And now at this point, the prosecution pivots to its second symbol. It sets up the symbol of the badge and what an officer is supposed to be. Then it sets up the symbol of betrayal, a period of time, 9 minutes and 29 seconds. The prosecution says, "You will learn what happened in that 9 minutes and 29 seconds. The most important numbers you will hear in this trial are 9:29. What happened in those 9 minutes and 29 seconds when Mr. Derek Chauvin was applying this excessive force to the body of Mr. George Floyd." Now, you see, the prosecution has given you a structure. They use that structure to lay out the case they are going to present to the jury. He continues, "So let's begin by focusing then on what we will learn about this 9 minutes and 29 seconds. And you will be able to hear Mr. Floyd saying, 'Please, I can't breathe. Please. Man, please.' In this 9 minutes and 29 seconds, you will see that as Mr. Floyd is handcuffed there on the ground, he is verbalizing 27 times, 'I can't breathe. Please, I can't breathe.' You will see that Mr. Chauvin is kneeling on Mr. Floyd's neck and back." Now, the prosecution spends the next few minutes going through in extensive detail what the evidence will demonstrate about those 9 minutes and 29 seconds and what happened during that period. The prosecution also talks about witnesses who are going to testify as to why that happened in those 9 minutes and 29 seconds that ran afoul of the policies of the police department. And the prosecution uses its most powerful piece of evidence. It plays the video of Chauvin kneeling on George Floyd's neck. That video we talked about at the beginning.
It's really well done. It's a very powerful opening statement. It really lays out exactly what the prosecution is going to say, and it really lays out their story and how they are going to prove this case. But it is interesting. There's a weakness in their case that they have to address.
Right. And the weakness is that the prosecution has to set up this idea that it will disagree with the official cause of death. That's a problem, right? We've talked about the official cause is the coroner, who's really supposed to be on the side of the prosecution. We've stated that the prosecution has aligned itself with the police force. And now it's having to say that one of its officials, the coroner, got the official cause of death wrong. The autopsy conducted by the authorities resulted in a cause of death of cardiopulmonary arrest complicating law enforcement, subdual restraint, and neck compression. But the prosecution says they will show that the cause of death was asphyxiation, going so far as to say this was not a fatal heart event. He died one breath at a time over an extended period of time. And the prosecution says it will be calling 6 independent experts to support that conclusion. The defense will seize on this dispute within the prosecution camp. Now, this is a big tension within the prosecution's case.
Obviously, you know what the prosecution's going for here. They want to say that what Derek Chauvin did killed George Floyd. And the best way to show that is that George Floyd died from lack of oxygen. He died because he could not breathe, as he says. And obviously the reason he could not breathe was because Derek Chauvin has his knees in his neck. And on the other side, you have this autopsy which says he died of a heart attack. Now, the thing that I find to be a little strange here, I don't know that the prosecution had to do this. I don't know that they had to take such a stark view of this, because it's almost setting it up to the jury. If you disagree with us, if you don't think he died of asphyxiation, if you think he died of a heart attack, we lose. They're almost sending that subtle signal. That's not what they're saying, and that's not what they believe. But by going for this, it certainly leaves an opening for the defense, and the defense is going to focus on that, and the defense is going to hammer on that. It would seem to me, and maybe I'm wrong on this, that if Derek Chauvin with his knee on George Floyd's neck resulted in him having a heart attack because of whatever, the stress or some lack of oxygen, that would be sufficient. So it's a little weird to me that they're doing this, but this is something the prosecution's committed to.
Yeah, I mean, we'll see how it plays out. Clearly, as you can tell from the opening statement, the prosecution has spent a lot of time on this case, and it seems it's a very good opening statement. They have a reason for taking this tactical stance, so we'll see how it plays out throughout trial.
So let's talk about the defense opening, and I actually think the defense opening is weak at first because the defense starts the same place that most defense openings start, and that's with reasonable doubt. And I don't want people to think reasonable doubt's not important. It obviously is. And if you can establish reasonable doubt, technically you win your case. But once again, this is the ultimate best story wins case. There is such a great story on the side of the prosecution. And just trying to talk about reasonable doubt, to me, isn't going to be successful. But nevertheless, the defense attorney, he dives right in, and this is the first thing he tells the jury. A reasonable doubt is a doubt that is based upon reason and common sense. At the end of this case, we're going to spend a lot of time talking about doubt, but for purposes of my remarks this morning, I want to talk about reason and common sense and how that applies to the evidence that you're about to see during the course of this trial. Reason is an idea that wholly permeates our law, our legal system, and it forms the foundation. And you will see and hear that repeatedly throughout the course of this trial. What would a reasonable police officer do? What is a reasonable use of force? What would a reasonable person do in his or her most important affairs? What is a reasonable doubt? As such, reason dictates and necessitates how the evidence must be looked at and analyzed in every single case. I mean, to me, this sounds like the opening of an evidence textbook, right? Like, the section on reasonable doubt could have started with that paragraph, and that would have been fine. The prosecution's just stood up and talked about the badge as a symbol and this 9 minutes and 29 seconds, and he comes in with this.
Exactly. And the thing about this case is obviously the prosecution, it was so specific to this case. It had a video, it had these gripping images, and then you have kind of the opening of reasonable doubt that not only could be part of a textbook, but could be the opening of any defense anywhere for petty theft to murder, and it's just not gripping in any way.
It's not gripping in any way. And you need to say all those words at some point, but I don't think that's where you start. And we all know that in any presentation, the beginning is the most important part. If the beginning doesn't grab you, oftentimes you'll just sort of forget. You'll lose track of what someone's telling you. You'll stop really paying attention. And so I wasn't blown away by that, but I think it gets better as it goes along. Really, once the defense does what the prosecution did and pivots to the facts of the case and attempts to turn the sort of main primary symbol of the prosecution on its head. And here's what the defense says. But the evidence is far greater than 9 minutes and 29 seconds. So here we're showing the prosecution is going to build its case on 9 minutes and 29 seconds. They said it again and again and again. The defense needs to broaden that. If all you have is 9 minutes and 29 seconds, the defense has a problem.
And Brett, that one sentence is a really effective way of essentially taking a sledgehammer to that built-in shelf that the prosecution just built, right? Up until now, we've kind of hammered into our minds 9 minutes, 29 seconds. And here he comes in with one sentence and swiftly says, that's the wrong view to look at this case. So I think that's a really effective sentence.
Right. And in doing that, he's starting to write his own story, right? It's no longer just don't believe their story because of reasonable doubt. It's they've got their story. And yeah, that looks bad for us, but here's the real story. Here's the truth.
And Brett, let's note this real quick. I don't know if he had written this originally or if this was on his feet, because even though you rehearse your own opening statements, you don't know the other side's story at all. Now, obviously, 9/29 has been in the news a lot. Everyone knows the timestamp, so it's probably a good bet that the prosecution will harp on it. But whether he knew that it would be the basis of how this kind of the repetitive symbol throughout the prosecution's opening, I'm not sure. So if this was on his feet, I thought it was good thinking.
And I think it was. I think if you look at the transcript, which we'll put on the website, there aren't transcripts for everything in this case, unfortunately, but there are transcripts for this, so you can actually read this. And it seems like it maybe was on his feet. And you're right, it's really good because the prosecution's all about that 9 minutes and 29 seconds. It's all about focus on Derek Chauvin, and to the extent you think about George Floyd, think about him during those 9 minutes and 29 seconds. And the defense needs to push past that. They need people to think about everything that was going on outside of that time frame. And look, this is controversial because people, and you see it in the media as this trial is going on, George Floyd's not on trial. Why are they attacking George Floyd? It doesn't matter what kind of person George Floyd was or what he was doing. And all that's true, but that is the key for the defense. The defense has to show somehow that what Derek Chauvin did was reasonable because of the person that he was up against, the person that he was attempting to arrest. And the only way to do that is to talk about George Floyd. So while it may be distasteful for people and it may feel just sort of wrong on a basic level, this is really the only course of action the defense can take. The defense can't say Derek Chauvin wasn't there, he's got an alibi, right? We know that. He was there. They can't say, George Floyd isn't really dead. He's dead. They can't say this was self-defense because we have video. It's not self-defense. So a lot of the defenses that a defense attorney ordinarily has kind of go away here. And the only real question is, was what Chauvin did reasonable or not? If it was reasonable, he's not guilty. If it wasn't reasonable, he's guilty of something. And depending on how not reasonable it was, he might be guilty of higher levels of a crime. And that's why the defense has to hammer on this, even if it seems distasteful at times. And they lay out what they're going to present. Here's what he says. You will see the actual video from inside Cup Foods. Mr. Floyd did use a counterfeit $20 bill to purchase a pack of cigarettes. So he's establishing, look, this all started because he used a $20 bill, counterfeit $20 bill. He then turns to try and focus on the danger, the perceived danger at least, that Mr. Floyd might have presented. And he says, so at 8:01, a second clerk from the Cup Foods called 911 to report Mr. Floyd. During that call, Mr. Camara, you will hear him describe Mr. Floyd as drunk and that he could not control himself. He's not acting right. He's 6 to 6.5 feet tall. So now he's putting out, what did the police know when they got there? What is the information they have? They have information that a man has broken the law, that he's drunk, that he can't control himself, and he's between 6 and 6.5 feet tall. So he's already trying to put in the jurors' minds, this is the mindset of the police as they arrive. And then he moves on. So you've got that, their mindset as they arrive. And then you've got what happens. You will see the officers struggle with Mr. Floyd to get him out of the Mercedes-Benz and handcuffed. So Mr. Floyd is actually in the driver's seat of a car when the police arrive. And you see this on the body cam video. So they're removing him from the car. And you will see and hear everything that these officers and Mr. Floyd said to each other. The evidence will show that when confronted by police, Mr. Floyd put drugs in his mouth in an effort to conceal them from the police. So you've got, he was drunk, he couldn't control himself, He's resisting when they're trying to remove him from the car. And to make matters worse, he's putting more drugs in his mouth during this critical juncture.
And so what you're setting up outside of the 9 minutes, 29 seconds, if you're the defense here, is that we heard the prosecution said that there was no struggle for Mr. Floyd, which is true within that 9 minutes, 29 seconds. Anyone watching the video can know that. What the defense is trying to insert here is there was a struggle outside of that 9 minutes and 29 seconds. And also to show that there was a lot more going on. They're trying to set up that there was a struggle, not just physically, but with compliance, with Mr. Floyd putting drugs in his mouth. They're just trying to insert all these little things that they're hoping will at least shift people's minds off of that video that they see.
And it's interesting because this is kind of the inverse of what you see in a lot of cases. In a lot of cases, you see the defense going for emotion. You know, when you think of jury nullification, you usually think of the defense doing that. Like the defense is trying to get the jury to ignore evidence. And in this case, not saying the prosecution is trying to do that, but the prosecution is obviously focused on the symbolism of the badge and the emotion of this and what you see in that 9 minutes, which cannot, unless you have a heart of stone, you are affected by that when you see it. And they want the jurors to remember that. No matter what happens in this trial, you remember that 9 minutes and 49 seconds. And the defense is like, hey, let's talk about the facts. Let's just talk about the evidence, right? Like they are sort of stepping back from that and just saying, we need to look at everything. You need to look at all the different evidentiary things. And they're kind of setting up where the fight is really going to be at trial, as you will see once we get to the witnesses. The defense goes on to say BCA agents located various pieces of evidence during both of these searches, including 2 pills that later analysis by the BCA revealed to be a mixture of methamphetamine and fentanyl. This is what's called a speedball, a mixture of an opiate and a stimulant. You will see that 3 Minneapolis police officers could not overcome the strength of Mr. Floyd. Mr. Chauvin stands 5'9", 140 pounds. Mr. Floyd is 6'3", weighs 223 pounds. So once again, trying to hammer this of the police officers in fear for their own safety. They can't control this person. There's drugs involved. There's drugs like fentanyl and methamphetamine involved. And Mr. Floyd is a big guy. Trying to hammer that into the jury's head to give them some doubt that what was going on wasn't reasonable. And then they really kind of dive into what you're going to see so much with the witnesses. To answer these questions, and the questions we're talking about is whether or not what happened was reasonable, the evidence will show that the Bureau of Criminal Apprehension investigated the Minneapolis Police Department's training and policies. You will learn about things such as the authorized use of force, proportionality of force, excited delirium, defensive tactics, including prone handcuffing, neck restraints, maximal restraint techniques, the swarm technique. So all these, they're getting into the manual, basically, right? So they're like, look, this is emotional, but you're going to learn about all these techniques. You're going to learn about training. You're going to learn about what these officers learn to do. You will learn about rapidly evolving situations and the Minneapolis Police Department's decision-making model. You will learn about crowd control, medical intervention, de-escalation, procedural justice, crisis intervention, and the human factors of force. That is what happens to a police officer or any person when they're involved in the high-stress use of force situation. And you will learn that Derek Chauvin did exactly what he had been trained to do over the course of his 19-year career. The use of force is not attractive, but it is a necessary component of policing. Once again, is this reasonable or not? And the defense is saying it was reasonable because he was trained to do this. If you want to blame somebody, blame the Minneapolis police. Once again, the prosecution and the police are on the same side. They're hand in hand. They're saying this Derek Chauvin's a bad cop. He's a bad guy. He's a criminal. You need to convict him. The defense is saying, no, he wasn't a bad cop. He was a cop doing exactly what you told him to do. And if he's doing what he was trained to do over 19 years, was that unreasonable?
Yeah, again, really effective of the defense to try to drive a wedge between the police and the prosecution here. And again, I don't know if he knew that they would align themselves with the police, but the more wedges he drives, the more potential one of those cracks can spread into reasonable doubt for the jurors.
And so to kind of finish up the defense's opening statement, they also are going to attack the prosecution in this weakness that even the prosecution acknowledges, tacitly at least, that it has in its opening statement. And that's the cause of death. So here's what the defense says about this. The state was not satisfied with Dr. Baker, who is the state pathologist, his work, so they have contracted with numerous physicians to contradict Dr. Baker's findings, and this will ultimately be another significant battle in this trial. What was Mr. Floyd's actual cause of death? And the defense goes on to say, Dr. Baker found none of what are referred to as the telltale signs of asphyxiation. There was no evidence that Mr. Floyd's airflow was restricted, and he did not determine to be a positional or mechanical asphyxia death. Now, on the one hand, you may ask yourself, what difference does that make? Sort of the question I was asking earlier. But the prosecution's kind of already said it makes a difference. In fighting this battle and choosing to fight this battle, the prosecution has said this is a battle we have to win. At least that's how I interpret it. This is a battle we have to win, and we're going to do it by lining up all these experts who are going to tell you, yes, this was an asphyxiation death. And the defense is in a really, a position you don't get to be in very often as the defense, where they get to say, we don't have to call a bunch of experts, a bunch of outside experts. We got the state's expert. We got the state's own guy saying that they're wrong. Another way this is sort of flipped on its head. Normally the defense would be calling 6 experts to say, oh no, this was a heart attack. And instead, they don't have to do that because they have the state's expert, and the state is going to have to refute its own person to show that this was an asphyxiation death.
Yeah, but that's so fascinating because they're kind of saying the quiet part out loud, right? You don't need all these experts. You really just need one expert, and the expert's already spoken, and they're supposed to be aligned with the state, and they just disagree with it because they're having to change the facts to fit their theory. We don't have to change the facts. The facts are clear. That's what the defense is trying to say.
So that ends sort of the build up to this case. From this point on, it's going to be witnesses testifying about what they saw, testifying about their various expertises. Obviously, the prosecution goes first, and they've got a lot of witnesses they are going to go through. Tomorrow, we are going to walk through the witnesses that presented testimony in this first week of trial. We'll talk about what they saw and what they said. Very interesting things about the strategy of the prosecution and the order of these witnesses and where they decided to start that I think reflects what we've seen already about the way the prosecution wants to build this case and what they want the jury to focus on. Alice, do you have anything else you want to add before we wrap it up for today?
No, I hope you've enjoyed kind of the recap of what's happened. And the way we've commented is leaving it up for you to decide, but we've pointed out the tactics and strategies as we see them in these opening statements, and come back for the presentation of the witnesses because there's a lot to discuss there.
Yeah, we're really committed to giving this to you guys in the least biased way possible because I know you don't get that very often. Know you probably already have thoughts. Hit us up, prosecutorspod@gmail.com, @prosecutorspod on all the social media. We're on YouTube. We're on Reddit. We're floating around all over the internet, so please do reach out to us. Thank you so much for all of you who are telling your friends about this podcast and leaving 5-star reviews on Apple. I hope you will continue to do that. As I said, we will be back tomorrow with another episode on this. But until then, I'm Brett.
And I'm Alice.
And we are the Prosecutors. I mean, to me, this sounds like the opening of an evidence textbook, right? Like,
right.
The section on reasonable doubt could have started with that paragraph, and that would have been fine.
And the thing is,
the prosecution just stood up and talked about the badge as a symbol.
Sorry,
and just 9 minutes and 29 seconds. It's okay.
I was talking, and I was like, man, never mind.
I'm just running all over you.
1 second because I hear a crying baby in the background.
That's fine.
Okay. I don't know if it will be picked up by here. I am in the closet.
So, people like to hear the babies.
I don't know. It was a really good touch, actually. Okay.
Shopify is a platform built for growth, whether you're just starting out or already running a thriving business. From managing inventory to creating a seamless checkout experience, Shopify is designed to handle it all. And it doesn't stop there. Shopify helps you sell everywhere your customers are, online or in person. It's the ultimate tool for turning big dreams into big wins. Sign up for your $1 per month trial period at shopify.com/OPP.
If you're looking to streamline your audio advertising buys and maximize your revenue, look no further than Triton Digital's programmatic audio advertising exchange, A2X. The private exchange consists of only licensed broadcasters and top-tier internet radio publishers, assuring the quality inventory and brand safety you can trust. Visit www.tritondigital.com to learn more.